Let's set the scene. You're driving in Maryland. Red and blue lights come on behind you. Your heart rate spikes because you already know this isn't about safety. It's about control, compliance, and collecting information that can be used against you. Today, we're walking through a Maryland traffic stop, step by step, what you must provide, what you do not have to do, and how police legally turn small talk into probable cause. And stay to the end, because one question can decide whether the stop ends in minutes or turns into a fishing expedition. And if you find this helpful, like the video, subscribe, and hit the notification bell so you don't miss future breakdowns. In Maryland, during a lawful traffic stop, you are legally required to provide only 3 things: your driver's license, your vehicle registration, proof of insurance. That's it. You do not have to answer questions about where you're going, where you're coming from, what you're doing, whether you've had anything to drink, whether there's anything illegal in the car. Silence is not suspicious. Silence is constitutional. Yes, in Maryland and nationwide, if an officer orders you out of the vehicle, you must comply. This comes from long-standing Supreme Court precedent allowing officers to order drivers and passengers out for officer safety. Important distinction though, comply physically, but not verbally. Getting out of the car does not mean you consent to questioning, you consent to searches, you waive your rights. Yes, when you exit the vehicle, rolling up the windows and locking the car is a smart defensive move, not obstruction. Why? Because officers frequently justify searches by claiming, "I smelled marijuana." Locked doors and closed windows limit, alleged plain smell claims, plain view observations, opportunistic searches. You are protecting your rights, not interfering. Yes, within reason. If an officer instructs you to, stand in a specific spot, sit on the curb, move away from traffic, you should comply. However, this does not automatically mean you're under arrest. It also does not mean you're being detained beyond the traffic stop, yet. Which brings us to the most important question you can ask. At some point, especially after documents are returned, ask clearly, am I being detained or am I free to go? This matters because once the purpose of the traffic stop is complete, police cannot legally prolong it without R.A.S. R.A.S. stands for Reasonable Articulable Suspicion. Here's the key point most people miss. The traffic violation itself is R.A.S. for the stop. It is not R.A.S. to extend the stop. Police must articulate new, specific facts suggesting a separate crime. Not nervousness, silence, refusal to consent, you didn't make eye contact, you seemed evasive. If there is no new R.A.S., the stop must end. That's why asking if you're being detained forces the issue. 2 major court rulings protect drivers, even if police don't like it. Rodriguez versus United States held that officers cannot prolong a traffic stop for unrelated investigations without independent R.A.S. Pennsylvania versus Mins allows officers to order drivers out, but does not grant unlimited detention or search authority. These cases have repeatedly held up in court, even when departments push the limits. Police are not there to serve and protect during traffic stops. They're trained to ask questions you don't need to answer, turn consent into cause, use your words against you. Your job is simple. Be calm, be polite, be silent, assert your rights. And if you want to go deeper into real-world police interaction breakdowns, check out Lackluster, Audit the Audit, Long Island Audit, The Civil Rights Attorney. They do outstanding work exposing how these encounters actually play out. If this video helped you, like, subscribe, and hit that notification bell, and drop a comment if you want to break down for another state.